If you're a founder raising funds for your startup, you probably plan to or have already issued a SAFE, or a simple agreement for future equity. The SAFE was released by Y Combinator and, according to statistics from Carta, now represents 93% of pre-seed convertible funding. Unfortunately, most founders don't know about four hidden traps with SAFEs regarding cap table clarity, tax problems, extra dilution for founders, and potential problems with unconverted zombie SAFEs. I'm Sam Wong from Fundable Startups, and in this webinar replay, I'll explain in detail how each of these four issues can cause problems for founders. In addition, I'm joined by Amit Singh, a partner with law firm Mintz, to talk about his Series Safe Preferred Stock, which is an alternative funding instrument that avoids these four hidden traps with the Y Combinator post-money safe template. Let's dive in. Good morning, good afternoon, good evening, everybody. My name is Sam Wong, and I'm here with Amit Singh from the law firm Mintz. We are going to talk about startup fundraising, specifically the trade-offs in the fundraising instruments between a SAFE and a Series Safe, which is a preferred stock instrument. Okay, so to get into to summarize why we're having this meeting, if you remember the famous scene from Admiral Akbar in Star Wars, when he gets into the problematic situation, it's a trap. And it's a little bit of a humorous analogy, but there are a number of hidden traps with safes. One that I see is tap table clarity. Another one, well, actually, from a founder perspective, that is a medium priority situation, and also for a investor, from my perspective, it's also a medium priority type of problem. Another one is that there's tax impact, and Amit's going to talk about that in a good amount of detail. From a founder perspective with safes, it's not a significant concern, but from an investor perspective, it is a significant concern. I invest with Band of Angels, and this is something I always ask about in terms of the investments I'm considering. Okay. Then there's an issue of founder dilution. Safes can increase founder dilution, especially post-money safes. From a founder perspective, of course, that's a concern, and investors, not much of a concern. And then there's an issue of potentially zombie safes in the unlikely situation where a safe does not convert to equity. There's a weird situation where the founders are, living life large, but the investor could get stuck. Okay. There is actually a fifth perspective as well, and that's about leadership. We don't talk about this a whole lot in the startup space, but it is something that in talking with seasoned folks over at the Band of Angels and a number of other startups, it is a concern. And to provide an analogy, as you can kind of tell, I'm a movie fan. One of my favorite movies about space is Interstellar. And in this movie, there's a scene where you see that little spaceship with the rings. There's two ships trying to dock with that ring-shaped spaceship. And the first ship actually fails, and there's a catastrophic explosion, et cetera, et cetera. And then the second ship, the pilot of the second ship is told, "Hey, what are you doing?" As the pilot is approaching the ring ship, says, "No point in using your fuel. What are you doing?" And the pilot, Matthew McConaughey, says, "I'm docking." Okay. And then he's told, "It's not possible." He says, "No, it's necessary." And it's a great scene. It's one of the best scenes in the entire movie. And the analogy that I would give here is someone who knows what they're doing can provide better governance, decision making, and control. Okay. And this is something that can be helpful for founders to get better help in governance and control and investor protection rights and things like that. It can also be something that is helpful for an investor as well. The reason I have it as a mid-level, yellow light, type of situation is not every investor is a master pilot. So most investors will try to communicate their prowess in piloting a startup. I'm not so sure every investor really merits the highest level of praise for their ability here. So that's an honest truth of what I've honestly seen in the state of the startup industry. Well, with that backdrop, I know Amit has a number of different perspectives, and we're going to have Amit actually introduce himself. Amit, please tell us about yourself and what you do.
Yeah, so I'm a corporate lawyer. I'm a partner at Mintz, and I focus primarily on venture capital and mergers and acquisitions transactions involving technology and life sciences companies. So I often represent the founders founding the company through all their then I represent the company through all rounds of financing and then some type of exit event. And then also I'm on the venture side as well. I've done well over 600 venture capital financings and well over 200 mergers and acquisitions transactions, and almost exclusively in the technology and life sciences space.
Okay, fantastic. Um, so mind a little logistical detail. Once I stop sharing, Amit, you should be able to share. Okay. So
Great.
thanks. By way of introduction, if you guys don't know me, my name's Sam Wong, and I have had both the pleasure and the pain of doing five different startups. The first two startups shut down, and the last three did get acquired, thankfully. There were also two other startups that I worked with on a fractional role that also got acquired. Startup number one raised the most funds. Startup number two had the best tech, and they both still shut down. And what I learned from this experience was the going through and seeing these companies have money or have great technology was execution really rules the day. So what we try to do now in my company, Fundable Startups, is we help companies become fundable, raise funds, scale, and then exit. Okay, and I also have a number of resources available. I do a startup training academy. I also wrote a book on startup execution. There's tons of resources. So if you go to my website, there's a lot of free downloads, roadmaps, free training classes to give you a perspective of the type of training that we build, et cetera, and why it's oftentimes we've had a lot of people comment it's some of the best training that they found on the internet. Okay. So in terms of this session here, we've already done a couple of quick introductions. We're going to just touch upon some early stage fundraising options, founder investor goals. We're going to skip the history of startup fundraising a little bit, and just talk about the most common early stage fundraising vehicle, which is a SAFE. And then skip some of the perspectives on the VCs and stuff because I want to get into. Oh, sorry, it's not series first, it's series safe. Sorry for left that out. But then get into trends, impact, and discussion. Okay. So this is an advanced topic. Okay. I do have a basic overview of safes. It's actually next week. If you are interested in understanding what a safe is in more detail, some of the nuances, the different variants, the histories of safes, I will go ahead and populate this in, I'll pop it in the chat window. Okay. And let's see here. Sorry for the delay. All right, so it's in the chat window. Go ahead, and if you're interested, you can sign up for that next week. Okay. So with that, let's go ahead and dig into some more of the content here. What I mentioned this series first. There is we did another session with another attorney from Ramon, who also created an alternative to the safe. Now, what you're seeing is that multiple attorneys are creating these alternatives, and you have to ask yourself, like, why? Right? Because they recognize the problems with a safe. Okay. Um, and Amit will be able to cover some of that in more detail momentarily. Did want to provide, in order to provide the baseline, just to make sure everybody understands some details about the type of stock in a company, common versus preferred. I'm not going to get into all the detail here, but basically the two types of stock are common, usually held by founders and employees, and investors who invest in the company. They want preferred stock because the preferred stock have extra rights and privileges. Okay. And if the goal is to get equity and common stock that is not sold to investors, it's only held by employees, and the investors get the preferred stock. Well, how do we get there? And conceptually, there's how, investors can loan money to a startup. How do startups raise money from the investors? They can loan money. There's usually an amount, an interest rate, a maturity date, etc. But loaning money to a startup is usually a very bad idea because there's a high risk that the money will never be paid back. And if the investors really want preferred stock anyway, then a loan doesn't really get them to that point. So, in order to solve that problem, these loans were created, an extra feature was created to allow them to be converted from something that's ugly to something that's more attractive to actually convert to preferred stock at some point in the future. And that yellow shaped L, that's the definition of a convertible note. Okay. Well, um, the challenge is that with a convertible note, what if the startup can't pay back the loan? Then the holder of the note, the lender, could foreclose on the note and have undue leverage to bully the founders. And to avoid this problem, Y Combinator removed the requirement to pay back the loan and created an instrument called a SAFE. It looks very similar to a convertible note. There is an investment amount, but there's no interest or maturity date. And just like a convertible note, it also converts into stock at some point in the future. So the most common investment vehicles for startups today are going to be the convertible note, the SAFE, and preferred stock. Okay. So in terms of goals, most founders want to just minimize dilution, understand what the dilution looks like, simplify the cap table. Investors typically want to maximize their ownership, minimize their risk, and optimize their tax situation. And shared between these two parties, usually want to reduce delays, minimize legal fees, and maximize certainty of how things will move going forward so that they can eventually build and grow the startup. There's usually other goals, but many times those other goals can be traced back to some of these core root issues. So, with that, I do want to just give Amit the chance now to be able to share. Let me stop the slides. Okay.
Like Sam mentioned, I created this thing called the Series Safe Preferred Stock, and the intent is to have safe-like economics, but it's actual stock. So it's a new funding investment vehicle for early stage companies that combines the simplicity of a safe with clear, qualified small business tax benefits and built-in stockholder protections. And the reason why I decided to create it is because over the years, I've been spending a ton of time arguing that SAFE is likely stock for qualified small business, qualified small business stock purposes. But it was never, but I've been asked for legal opinions on it, et cetera. We can't give a legal opinion on that because it is not clear. And so that's why I decided to create this. And keep in mind that if you decide to adopt this, you don't have to use me to use it. I'd love for you to do it, but you can always go to seriesafe.com and use these for free. So they're effectively open source. You can use them however you like and with whatever attorney you like. And frankly, whether or not you use safes, notes, or Series Safe preferred stock, I do recommend at least you involve an attorney because there are, even with the simplicity of a safe, there are issues that come up that are surprising to founders when they don't have an attorney involved. So let's talk about the problem with safes. So they're unbelievably popular. I think Carta says that 90% of pre-price rounds are on safes and the other 10% on convertible notes. And then even after that, I think it's 65% are safes and maybe 20, 30% are priced rounds and the rest would be notes. So they're unbelievably popular. So like I mentioned, the IRS may not treat a safe as stock until conversion, which you're potentially delaying the qualified small business stock holding periods. And I'll get into more detail about qualified small business stock, but those holding periods are 3, 4, and 5 years for a 50%, 75%, or 100% exclusion. So you're of the greater of $15 million or 10 times your basis. So if you get to 5 years holding, then you can exclude the greater of $15 million or 10 times your investment, your basis in the stock. Safe holders also are contractual parties. They're not stockholders. So they lack arguably at least, they lack the fiduciary duty protections that Delaware corporate law provides to all stockholders. And that's why a lot of times, although it seems really easy to negotiate these safe deals, there's often a long negotiation about a side letter where a sophisticated investor will say, well, wait a second, I want information rights. I want some kind of protection from the founders increasing their salaries without my consent. We need some kind of protection. And so you end up negotiating this side letter. So it's often not just one document, it's at least two documents. And there's no statutory rights. So you don't have access to books and records under Delaware corporate law. And again, if the founders want to increase their compensation or do something else that's sort of an interested transaction, there's no real protection against that unless you have some kind of side letter that protects you. And the safes, rely on just their contractual thresholds for amendments. But again, there's no statutory protection against adverse changes versus the Series Safe Preferred. If you treat them differently than other classes of stock, then they get a separate vote. But otherwise, they're non-voting because it is meant to track the Series Safe as much as the safes as much as possible.
Yeah, and maybe along those lines, I can kind of share one thing. Um, uh, there was a situation where I was considering an investment, and the founder presented me with a convertible note. I saw a significant opportunity in the company, so I went ahead and I wrote a check, but I wrote a much, much smaller check than I wanted to. The reason being was that that particular convertible note allowed other note holders, basically majority note holders, to change any term that they wanted. I'm like, what is that? Okay, and I was signing away basically a contract that gave them a blank check to change anything they wanted. And I'm like, I don't like this. Okay, and I spoke with the founder about it. I said, hey, they're not changing it because they templated the note, etc. Just because you have a contract doesn't mean the contract can't be amended in the future. Okay. And as a result of this situation, I decided, okay, so fine. I like the startup. I hate the investment contract. And I wrote a small check instead of writing a much larger check. So that's the real reality of what can happen when you go with a contract-based solution for a fundraise.
And that's a great point, Sam. So is a safe stock for qualified small business stock purposes? And keep in mind that I'm often on the side arguing yes, right? And I hope that they are. But again, the answer is uncertain and the stakes are high, given especially the expanded QSBS rules. So what are the arguments that it is stock? First, it is intended to convert into equity and it's designed to function economically like stock. And the terms even say it is meant to act and be treated as preferred stock. Y Combinator, the creators of the safe, and practitioners like myself have argued that they are stock for tax purposes based on the economic substance of the instrument. And some advisors, again, including myself, treat the safe purchase date as the acquisition date because of its equity-like characteristics. But the IRS has not issued formal guidance, and the IRS has not issued any guidance saying it's not uh, stock, which is great. But there are arguments that it's not stock, and a lot of people push this. And a lot of times when I represent the company, I'm arguing against this. It's not issued under the company's charter, the certificate of incorporation. It's a standalone contract, and unlike stock, it's authorized, and it's not authorized and issued pursuant to the certificate of incorporation. So if you get preferred stock, you have it authorized under the charter, and then you get issued a certain number of shares. Here's just a contract saying that this is what you get, and this is what happens in the next round, et cetera, or what happens on an exit event, or what happens if there's dividends. But again, it's
And
a contract.
Yeah, and maybe to provide a little bit of context for folks who haven't been through the process, what Ahmed is talking about here is fairly significant in that preferred stock, when you issue it, create it, sell it, etc., um, it's actually referenced and defined in the certificate of incorporation for the company. So it's not, you can change it, but then there's a process to change it, and the any stockholder who well, the stockholder has a better chance to be able to vote for or against any proposed changes. It's not quite as simple as just, oh, let's just amend the contract or whatever.
That's right. And, again, a SAFE is a contractual right to equity in the future. It's arguably not stock itself, and it typically doesn't appear on the cap table as issued shares until conversion because it's, again, not shares. And Section 1202, the QSBS provision, requires stock to be issued by the corporation. And a SAFE, again, may not meet this definition until it actually converts. So you do the next round, it converts to preferred stock. Clearly, that's stock. Again, we're talking about the period before conversion. And the IRS could apply a strict legal form analysis. No stock certificate, there's no stockholder rights, no fiduciary duties, and the IRS could say, as a result, it's not stock. And again, there's no IRS ruling one way or the other, and there's no case law one way or the other. So you're taking a position that it's stock, and again, we take that position all the time, but again, we just don't know what the IRS would say. So the point is that the series safe eliminates this ambiguity. It's clearly stock upon issuance. So as long as the other requirements for being qualified small business stock, it's issued by a corporation, et cetera, and I can go over those details in a moment. But it's clear that the holding period starts on issuance. So you don't have to worry about that argument anymore. And so how does it work? So it's stock from day one. So you buy one share of Series Safe Preferred by a very simple stock purchase agreement. And that stock purchase agreement provides virtually the same representations and warranties as what's in the Y Combinator safe. So it's very simple. It's 3 pages. It's very basic. And you become a stockholder immediately. You're not a contract holder waiting to convert to stock. And the economics are exactly the same as a stock. So it has an investment amount and a post-money valuation cap that drive the number of shares that you get upon conversion. So the cap table outcomes look and feel exactly the same as a safe. So if you were getting a safe you're investing $1 million at a $10 million post-money valuation safe, then you before conversion represent 10% of the cap table, and then afterwards, it depends on how much is raised, et cetera. But the calculations would be exactly the same as a safe. But in addition, you also have Delaware law protections. So you're owed fiduciary duties, so that the founders can't just start issuing themselves, giving them more equity. They can't do deals with their own personal company that can be a supplier to the company, et cetera, without owing duties of care and loyalty to you as a stockholder. And you also have the right to books and records. So you have the right to try to get, what are all the financing documents? What's the charter of the company? What are the minutes, et cetera? What are the things that are relevant to me determining what's the value of my stock? Often people invest via safes and they have no access to any information. And again, that's why you have negotiations about these side letters. And so having this likely will reduce those negotiations. Somebody might still want a board observer or some other things, but the need for that side letter is greatly reduced. And you have class vote protections. It's generally non-voting, but you do have a class vote protection if you're treated differently. If the series safe preferred stock is treated differently than the other classes of stock, then they will have a vote. And again, that's all from issuance. You're not waiting till conversion for all that to happen. And again, it's stock from day one. So the clock starts immediately. So those 3, 4, 5 year dates start immediately, and that is clear versus making an argument at some point that that's when it occurred, was on issuance and not just on conversion.
And by the way, on some of those Delaware law protections and information, I can say for the investments that I hold, about 1/3 of the investments, I do not get investor updates, either because I wrote a check that was too small or they don't issue investor updates. Regardless, it's something that I wish I had more visibility towards. So the getting access to information is something that is significant after the investment is done.
Yeah, and that's why, my clients, we have each of my venture fund clients, we all have our standard safe uh, side letter, and it has things like access to information rights, often has some type of blocking rights on certain actions by the company, or at least a baked in fiduciary duty type concept, maybe observer rights and things like that. But then that all becomes an additional negotiation. And again, you would need less of those things. Not to say that a sophisticated investor is not going to come and ask for those things, but from an investor perspective, at least if you're not don't have the power to negotiate something like that, you are getting a lot of those benefits to begin with.
Okay.
So
Maybe we could take two quick questions that have shown up in the chat. Question from Alan: Is Nevada C corporation law also apply similarly to this Delaware situation?
yeah, that's a great question. And you're right. Nevada is becoming very popular as an alternative to Delaware, as is Texas. We've got Elon Musk. There's the whole Elon Musk case. And so yes, it would have to be slightly modified, but barely modified to work as an amendment to a Nevada, Texas, New York charter. So it could easily be used for that as well.
Okay. I'm gonna guess that the question might be, does Nevada corporate law, to your knowledge, offer the similar protections and benefits to a stakeholder as Delaware corporate law?
Well, the reason why Texas and Nevada are becoming more popular is because the founders of the companies that are going to those states instead of Delaware believe that the protections for the minority stockholders, the other stockholders, is less. That is the point of going there. And so it's not the same. Delaware recently amended its code. There's some litigation as to whether or not that amendment is effective to try to get something closer and get more clarity because there was a case that came out that created all this controversy, one of which was the case involving Elon Musk. But it provides greater guidance, what we call a safe harbor to the board of directors of a company to prevent, to make Delaware more attractive to be more like those other states. But there's still some arguments that those states are more founder friendly than Delaware. And so that's
Yeah.
exactly why they go there.
So what we're hearing is that there's the various state domiciles, Nevada, Texas, Wyoming, etc. That is a bit in flux. I've actually spoken with an attorney who specializes in, your domicile for the corporation. It is in flux, and what I would say is what most people want is certainty. Okay. And as some of this stuff is evolving, it gets uncertain. Delaware has been they've had preferred status in general because it's such a mature state with lots of case law, lots of systems and processes to be able to handle some of these corporate issues. So it is generally viewed as fairly certain, even with some of the potential concerns that some very corner case corporations have run into. Okay. Delaware has seen a number of corporations leaving Delaware for the domicile to other states. So the legislature is trying to address some of that so that, they actually get a good amount of traction revenue, et cetera, for being the preferred, the most common place to domicile your corporation. So they're trying to be adaptive to some of the concerns. We'll see how it all plays out. At this point, if I, without doing lots of low-level detailed research, if I was starting a corporation, I'd probably just settle for Delaware because it's common and it's well understood, and the likelihood of me running into some of the corner case issues is probably pretty low. But consult your attorney for your specific situation for sure.
Yeah, and Sam, you make a great point. As far as predictability, That's why nobody forms in California. California is not predictable, and also it's it doesn't have a sophisticated, dedicated court like the Delaware Chancery Court, and Texas has created a competitive court as well. But every single corporate lawyer in the country understands Delaware corporate law,
Hmm.
and so you already have that baked in understanding. And there's so much history of litigation under Delaware corporate law, so that's why it's still very dominant. But again, there are those corner cases you mentioned.
Hmm.
And how does this work? Just to show you how it works is so you file an amendment, and again, these can be accessed at SeriesSafe com. And so there's two documents. One is you file a charter. So basically a charter amendment. You can use your existing charter, not even touch it, and just file this amendment that with Delaware that creates the preferred stock and defines the conversion rights, the fact that you get a share in dividends, and your priority over common stock. And then the investor, via a simple purchase agreement, buys one share of Series Safe preferred stock via a purchase agreement. So you don't have to calculate, well, what number of shares should I get? It's always just one share. But what really matters is just your investment amount and the post valuation cap. That's going to determine all your economics. It's also going to determine your vote when, in those few cases when you're allowed to vote. And it's also going to determine your right to dividends. And all that ultimately comes out to the same economically as a safe. And it establishes your stockholder status. Immediately under Delaware law, you're a stockholder. So you're owed fiduciary duties, you've got the inspection rights, and your qualified small business stockholding period starts. And there's a no there, and during the interim period, again, before you convert, you're generally non-voting, but again, you get dividends if there's dividends, and you get some kind of class protection against being treated differently than the other classes. And in the next round, exactly the same as a safe, you're going to convert into preferred stock at the lower of the price of the round and your post-money valuation cap. So again, the economics are going to be the same. So when that round closes, whether you're under a safe or you're under Series Safe preferred stock, your end result is going to be the same after conversion. And so here's a little chart. Again, from day one, it's preferred stock versus a contract for equity. The holding period, again, clearly begins at purchase, may not with a safe begin until conversion. Under preferred, you get full Delaware fiduciary duty protections. Under traditional safe, you do have what's baked into all contracts, which is an implied covenant of good faith and fair dealing, but that is very limited in its protection versus you have all this case law on what protections you were getting. And then again, you get access to information, you get inspection rights, you get to look at the books and records. Under a safe, unless you've got a side letter, you've got no such right. And then again, it's generally non-voting, but you do have a vote if your class is being treated differently than any other class when amending the charter. And again, a traditional safe, there's no vote. You do, if you want to amend the safe, then a majority of the safe holders with the same cap uh, have to agree. So you do have protection there. And then conversion, exactly the same. They both convert at the next round, and it's based on the valuation cap or the price of the next round, whichever gets you more shares. So again, it's the same economics. You get stronger legal footing and clear tax benefits. So just to remind everybody why you care so much about qualified small business stock. So under the One Beautiful Bill Act, the cap was increased, the cap of your so basically you're excluded from federal income tax the greater of 10 times your adjusted basis, or now increased from 10 million, $15 million so whatever is greater. $15 million or 10 times your adjusted basis in the stock. And the threshold for the company's gross assets to still qualify for issuing qualified small business stock is 75 million, increased from 50 million. And there's a tiered holding period. The exclusion is 50% at 3 years, 75% at 4 years, and at 5 years, the full 100%. So again, the clock starts at purchase. You are very clear. You don't have to wait for a conversion, and the partial exclusions kick in earlier, and you have greater flexibility. You can under the new bill, you can exclude $15 million rather than 10 million as the cap from uh, your federal income taxes.
And by the way, this is getting to be with sophisticated informed investors. QSBS is an absolute must. On $15 million of capital gain, you're with today's tax rates, federal taxes you could probably be in the 20% capital gain tax bracket. There is a 15% bracket, but that's for lower income owners. Once you're getting such a big gain, you're probably going to get bumped into the 20% bracket. So 20% of $15 million means you have to pay $3 million in tax. So that's a significant tax bill. So sophisticated, informed investors care a lot about QSBS. I always investigate QSBS eligibility with every single investment I'm going to make.
Yeah, it really is paramount because you're playing with house money, right? It's the government's money we're all playing with here. So it's in everybody's best interest to maximize the tax benefits of this investment. And you may wonder, why would I want to go with an instrument like this that does give those fiduciary duties to the investors? Often you do care about your investors. You want to do right by them. You want to provide clarity to them because you want them to invest in your next company. You want them to get the maximum return possible. And you're you also want to be able to give them the biggest return possible, right? And if a lot of their money is going to the government that could have been saved, that really doesn't make sense for anybody. And so, what are the requirements for a company to issue qualified small business stock? And the company and the stockholder both have requirements. So it has to be a domestic, a U.S. Corporation, and it has to be taxed as a C corporation. It can't have greater than $75 million in gross assets before or immediately after the issuance. At least 80% of the company's assets must be in an active business, a qualified trade or business during the holding period. And it can't be an excluded business like a law firm, accounting firm, banking, hospitality, things like that. And the company can't, this is something I've seen many times companies blow. The company can't have significant redemptions. A lot of times when you do a round of financing, the the founders are allowed to sell some of their stock in the round, which is great. You want to allow them sometimes to take some money off the table so they can buy a house, feel comfortable, but still have enough skin in the game to take you to the end. And I've seen it where all the money from the investors goes into the company, and then the company redeems some stock from the founders, and then that can make it so all the stock is no longer qualified small business stock. And that's why it's typically a secondary transaction where the company takes in some of the money, but then the rest of the money goes to the founders to buy their stock directly in a secondary transaction. So that has no effect on qualified small business stock uh, issuing ability of the company. So the stockholder itself has to be a non-corporate tax holder, can be an individual trust, even partnership and S corps can hold qualified small business stock. They can't issue it, but they can hold it. And the stock must be acquired directly from the issuing company. So if you buy stock from a founder, that's not going to be qualified small business stock. But a lot of times in those secondary transactions, you're outside QSBS at that time anyway. So the company's grown, and that's why you're willing to let the founders take some chips off the table. Um, but again, it can't be, and the issuance must be for cash. It can't be that you got it for services or an asset contribution or something like that. And then again, the holding period, you have to hold it at least 3 years to get 50%, 4 years from issuance to get 75%, and 5 years to get the full 100%. And the exclusion cap is the greater of $15 million or 10 times the taxpayer's adjusted basis in the stock. So why should you use it? You're given a greater ability to attract sophisticated investors. Offering them qualified small business stock treatment from day one aligns both the founders and the investors' incentives to the maximum extent, and it reduces the need for side letters because again, they get some baked in protections that you don't have to negotiate. And also those protections are understood. Your lawyer can advise you on what those are. Fiduciary duties are well documented, well litigated under Delaware law. And then you have the same cap table simplicity. You you know that if you invest $1 million in a $10 million post money safe, you at least represent 10% of the pre-conversion cap table. You don't know what it looks like later on, but keep in mind that you have the same problem with this as you do with safes as far as stacking them. So you have to be very careful issuing a bunch of safes at different caps, or maybe there's discounts baked in. You have to make sure you're really keeping track of the cap table, and you should, use Carta or something else to be tracking that so you really understand what the effect is of issuing safes or Series A preferred stock. But again, generally there's no blocking rights. They're generally non-voting. They can't block a new financing, and unless they're being treated differently than other stock. You're trying to dilute them at a different rate than other stock or something like that. But the founders retain their operational flexibility. It's not like the NVCA forms where you have a series of protective provisions saying thou shall not do XYZ without our consent. You don't have that. And these are just off-the-shelf documents you can take from the website Series Safe Preferred Stock. And again, you don't need me for it. The major caution I would have with this over a safe is that since this does cause conversion of the safe, so safe converts in the next preferred stock round. So this is a conversion event. If you had safes outstanding, this is a conversion event. So be very careful on what that means, what the investors are going to get. For example, if you use, forget about the valuation cap safe, but if you use a discount safe, rather than paying $1 per share, you'd be paying, if it's 20% discount, you'd be paying 80 cents per share. So that is likely not the intent of what you're trying to accomplish. Your goal is to be treating them the same as everybody else. So if you were to convert existing safes into the structure, you would want to amend those safes so everybody agrees on what it looks like.
Hey, Amit, can I ask a couple of questions? Because you raised a couple of fairly significant issues there on this previous slide. Can you back up to the slide? So mechanically, if we were to use a
Sorry,
Series A,
which slide did you want me to go to?
just the previous one you were on. Okay. So mechanically, when you buy one share of stock as part of the Series A preferred, what is the share price of the preferred stock?
Yeah, it's $1.
Okay.
So you don't have to do all these complicated calculations to try to figure out what is the share price. It's just $1. So if you invest on and well, actually, it's not a share price. You're sorry, you're getting one share. So it's
Yes.
not $1 per share. You're getting one share. If you invest $1 million or $10, you're getting one share. All the
Understood.
economics, all your rights are based on your investment amount and the post money valuation.
Okay. Got it. So effectively, are you saying then that the concept of a share price is not applicable or relevant at this point in time?
That's right. Yeah, you don't have to calculate a share price here. Uh, your your share price, yeah, it really just isn't meaningful at this point. And
Okay.
the point of that is to make it very simple. Otherwise, you have to, like if you're price round, you have to figure out, well, what is my share price? What's the fully diluted capitalization of the company? What's the post-money valuation? What am I investing, et cetera? You don't have to go through all those hurdles.
Would there potentially be any issues with basis price then? Let's say I do a $100,000 investment. I buy one share. Okay, share price is unspecified, I guess, or at that point. But the startup does well, gets an exit, I get a multiple return, and then on the year that the return comes in, my proceeds come in, I have to declare it on my tax return. And is there a potential issue of um, after the safe converts, I'm not going to get one share anymore. I'm going to get a lot more shares than one. Let's see, assume it I get 100,000 shares for the $100,000 investment. Would I then basically say if I got 100,000 shares for my $100,000 investment, now the acquisition price is $1?
No, your basis is still the amount you invested, which is
A dollar
$100,000.
per share, but I mean 100,000 for the block.
Right. Yeah. So
Yes.
the share price wouldn't be what you base your basis on. It's your
Hmm.
investment amount.
Okay. Understood. All right. Thank you.
For sure. And then, yeah, so again, you can just go to the website and download the uh, stock purchase agreement. It's a very simple, short form. It's 3 pages. It sets the investment amount and the valuation cap. It's very clean. The reps are virtually identical to the reps in the safe. And then you've got the charter, uh, which is very simple. It's just got an Exhibit A that has all the similar language to what's in a safe that it defines the conversion mechanics on the next round or a liquidation event, what you would get in dividends, your liquidation priority, which is effectively like preferred stock, which is what it is, and your voting rights under Delaware law. Generally non-voting, except as required by law.
Okay. Got it. Sounds great. Um, Thank you much. I wanted to cover a couple things just to real wrap up here. So I'm gonna go ahead and share. Okay. I had a bunch of other slides, but given the time and where we're at, I'm gonna jump to maybe a couple things to summarize. Okay. Um,
But by the way, while you have the slide up, Sam,
oh
Peter
yes.
Walker is somebody, if you're interested in venture capital, Peter Walker from Carta, is somebody you absolutely should follow. He's amazing. Carta has so much data available to them, and he shares it all the time on his posts, and it's
Hmm.
an incredible resource. He's brilliant.
Yeah, yeah, absolutely. So one of his posts here talks about how in 2025 the number of safes and convertible notes has increased by 3.8x. Okay. But I did want to point out that there is that challenge with cap table clarity. In fact, in the same post, Peter talks about how to wreck the next round's math. Okay. And he says too many convertibles can completely wreck the next round's math. And his comment is, give me a good standard priced equity round any day. Okay. So that's exactly highlights one of the big issues that Amit has been speaking about here. Um, in terms of priced equity rounds, the most rounds, would you say, typically rely on the NVCA documents? Most price
Yes.
rounds? Yeah,
Yeah, the vast
that's what I
majority
said.
do. Even if some people do really early on, they do a simplified preferred stock issuance.
Hmm.
The benefit of that is there's fewer documents, but your lawyers like they're not, there's not such a standardized version of that. So
Hmm.
lawyers will require some time to deal with that. But a bigger loss to you is that in the next round, it is going to be the NVCA forms, and so you're going to be starting anew, increasing your cost of the next round, and your leverage may not be as high in the next round. So it's better to have when you do your first price round, even if it's a seed round, I typically base it on the NVCA forms because then the next round I just redline against the prior forms and everybody just works off of that. And so whatever negotiating power I had in that early round, I hopefully can maintain in the next round, but regardless, it'll make it easy for the investors to know, well, what changed in the rights from the prior round. So if you're going to do any price round, I generally recommend the NVCA forms regardless of the fact that you might save some money at the outset, because in the long run, it'll make negotiating around much easier.
Okay, understood. And for those who don't know, NVCA is the National Venture Capital Association. They do a lot of policy type stuff, et cetera. And they provide a number of model documents for the priced round, which are mm, not quite ready to sign exactly, but it's a template. Many attorneys will start with those documents. And for the sake of time, I'm not going to go into every little detail here. But if you go to the NVCA website and you download the entire document set, what you're going to get is the nine documents here, and the number of pages of each individual document is substantial. The in the template itself, it's 250 pages. In the final documents, it might be shortened to 200 pages or whatever else. But that's why priced rounds can result in $100,000 in legal fees. And because of this huge cost, that's why most startup founders, unless they're raising large dollar amounts, they don't use NVCA. Okay. Peter Walker says, give me a priced round any day because it's just cleaner, it's smoother, there's lots of benefits. It's very much in line with what Amit saying. But up until this point in time, the most common way to do a priced round was NVCA, and it's going to cost you. Okay. And that's why there have been a number of attorneys who have tried to solve this problem. So if you look at the common funding vehicles in landscape, I like to look at it as a two by two matrix. One axis is going to be the complexity of the term, simple versus complex. Okay. When, of course, the complexity is going to be proportional to your time and your cost. And then on the other axis is the certainty of which is what you're signing and investing in, is it equity? And if it is equity, how much is it worth, et cetera, et cetera? And would it benefit, would it qualify for QSBS? Okay. So that gives us a two by two, and convertible notes, in my opinion, are there are not very many standardized convertible notes, so it's hard to be able to say. But let's assume that complexity is somewhere in the middle. But it's certainly not equity. Okay, there's a variant of a safe. The original safe was called a pre-money safe. That was used for about 5 years before Y Combinator revised it and created a post-money safe template. Today, the vast majority of safes are post-money safes. If you want some detail about the difference between them, then that's what next week's webinar is for. The Series A NVCA documents is big, fat, complex. It's definitely on the lower right-hand corner of this matrix. There is a lighter weight version. You might say NVCA on a diet. Okay, that's Series Seed. It was created by Ted Wang over at Fenwick, and I've seen it used from time to time. There's another one called Safe Preferred from FTB Gibbons, Series First, which is what we covered 2 weeks ago, and then Series Safe from Amit here. All right, and looking at this, if I had to kind of help visualize the journey here and draw a line, if you reduce the two by two to a single line, I would draw the line this way, partially because if you just looked at the page count of the documents, and page count kind of implies complexity, you see that pre-money and post-money safes are fairly short, okay, into their page count, and Amit's series safe is 10 pages. Okay. It's reasonably light. Okay. Whereas, of course, the most common priced round with the NVCA documents, that's over 200 pages. All right.
One thing I would say, Sam, is that people should be cautious in focusing only on complexity and cost at the outset. What you
Good point.
are giving up is if you do a price round, everybody after that round gets diluted by new stock that's issued. And
Yes.
it's hard to argue that every dollar invested in the company doesn't increase the value of the company by a dollar. With whether it's my series safe or the post money safe by Y Combinator, you're effectively issuing non-dilutive stock. So the stock cannot be diluted until the next round. So every dollar you add to the company is a zero-sum game. You're reducing your own equity ownership in the company until that priced round. And so when if you issue a $1 million or $1 million safe at a $10 million post-money valuation, that person gets 10%. And then the next person who also gets $1 million safe for at a post-money valuation of $10 million of the existing cap table, now they've got 10%. Now you've given up 20%. Versus if it was a price round, then you would share in the dilution of that next. So you would share in 90% of it, and
Mhm.
they would share in 10% of the dilution of that next $1 million. But instead, you as the founder are receiving 100% effect of that dilution. And that continues to occur as you issue post-money safes or Series Safe preferred stock until the conversion event occurs. And then from then on, it's you all share pro rata in dilution. And so that's just the one thing that I think gets lost by people thinking about, oh, it's just cheaper, it's more
Mhm.
simple, etc. And those things are all totally true. But you are giving up something significant for getting that simplicity.
Yeah, yeah, absolutely. Definitely look at what it is that's important to you. A bicycle is cheaper than a car, but there's a very big difference in the value that you get and the utility of the car. So definitely want to keep that in mind. I'm gonna start going through some of the questions in the Q&A, and while we do that, as part of some of the training packages that we have, if you're interested in our training, take a look at this. A lot of the content that we have here is representative of some of the things that we try to put into the training. A lot of the low-level mechanics that we don't have time to be able to cover here is going to be in the training package. So let me go ahead and oh, there was one thing I wanted to ask Amit. You also mentioned um, what should you do if you're a startup and you've already signed two or three convertible notes, two or three, four, five safes, whatever. Okay. And now you're looking at potentially, hey, this might be a benefit. I would like to use Series Safe Preferred. What would you recommend?
Well, if the reason is because you're able to raise more money, because you use a stock, the Series Safe preferred, then I think that makes total sense. But what I would do is I would look at what my existing securities are and think of what's the effect, since
Hmm.
this is likely a conversion event. I mean, some might have a minimum, if it's a
Hmm.
convertible note, might have a minimum raise for conversion. But the things that will convert once you issue the Series Safe preferred stock, you need to understand the effect on your cap table. For example, as I mentioned, if it's a 20% discount, that's not going to be what you intended. So what I would do is talk to those investors, get them to agree to convert,
Hmm.
and get them to agree to convert in a way that everybody understands what the effect is, rather than just issuing it, having the conversion, and then thinking, oh, wait a second, maybe that's not what I intended the economics to be. So make sure you understand it, have that discussion if necessary, and then do it. And then the benefits to them, again, is clarity. And so there's an incentive for them to agree to the conversion. But of course, if the economics are not going to make sense to them, they're not going to. But otherwise, there is a benefit in everybody agreeing to that. So again, I would have that discussion if there is some potential issue with the cap table effect.
Yeah, got it. So um, that can be what you're describing can be actually difficult to do if you have six, even if you have as little as six or seven investors. Um, it can be difficult to one, get them all to understand the situation, what you're proposing, because you're basically telling them, hey, we want to change the terms of the contract that you signed. Okay.
Yeah, but you may not have to get everybody to agree, right? The smallholders may not need to agree
Hmm.
depending on what the amendment provision says. If it's a majority of the amount raised under that particular security, then you just need to get a majority to agree. But you're right. And it may not be possible. So, everything's ultimately a case by case basis.
Okay. Got it. And to be clear, most safes that you've seen, at least the template, does not have a minimum qualifying conversion trigger for a qualified financing round.
That's right. And that's why, like when I represent investors, we have a side letter that says you can't convert us unless it's at least X dollars. And the reason is because let's say my client puts in $5 million into a safe. It can't be the case that the company raises $100,000 and that dictates the terms of my client's $5 million investment. Uh,
Mhm.
but often people don't think about that, and it gives the founders some advantage there. And my security does not fix that purposely because the goal is to match the terms of the save as
Mhm.
much as possible to make it easier for folks to adopt this, easier to get the benefits. you can
Mhm.
easily add that. And I thought about adding options for all those things,
Mhm.
but then it's just going to make it longer.
Right.
But if you involve a lawyer, they can easily add those types of things.
Yeah, and this kind of underscores the point is most people view signing a safe as a simple mindless transaction because everybody does it and they just sign the standard agreements and stuff. Um, what we're talking about here is there's corner case situations that your counsel needs to be aware of so that it can help you understand and make the best business decision. Oftentimes, I've seen founders who just signed a whole stack of saves, and when there is a conversion event, they didn't realize, oh, and that's part of the cap table clarity issue. There's all sorts of corner case issues. So, yes, you can sign safes without counsel, and but just be that may not always be the benefit to be penny wise on the legal fees and pound foolish later down the road. So,
Absolutely.
so there are a number of questions, and we're at the top of the hour. I know Wes has his hand raised. If Wes, you're still here, I've opened it up so you can unmute yourself if you'd like to ask a question live.
Yes, I have a dumb question, perhaps. The I want to know if we do a safe preferred under the QPS criteria, if the initial $5 or $6 million that we raise, which is well under the $31 million, is all going to be spent on R&D. So can we, at the end of the R&D period, and we've validated the prototype, can we then credit the initial investors the entire, say, $5 or $6 million they invested, since that was all spent on R&D? Can we give them the $6 million tax credit in exchange for them converting their preferred stock to common stock?
I guess I'm not totally sure I understand the tax. You're talking about an R&D tax credit?
Yeah, the OBBA offers a tax credit that for R&D. And so I'm asking if we can offer the initial investors all of their money back, since all of the money was spent on the R&D to develop this first article prototype. So can we give them this tax credit under the OBBBA, plus give them plus convert their preferred stock to common stock as part of the agreement, so they get all their money back, plus they have an equity stake.
To be honest, I don't know how R&D tax credits can be transferred to your investors. I'd have to talk to one of my tax partners that has that expertise, but that would be beyond the scope of my expertise, frankly.
Yeah, in my experience, again, I'm not an R&D tax credit specialist, but the R&D tax credit that I've usually applied for is a payroll tax benefit. I'm not, I've never heard of a situation where if you spend 5 million on R&D, that all 5 million comes back in some type, or now your tax burden is $5 million less. What I have seen is on the R&D tax credit, if you qualify to for that R&D tax credit, some portion of your payroll taxes is rebated back to you, okay, as a company, okay.
Right. But I guess
Yeah,
I've
but
never
that was
seen
only
that
for
go to
Social
the
Security
investors.
tax, and but the OBBA it appears to say, hey, up to $31 million, the corporation gets this tax credit, and it has to be for the company, which is essentially the shareholders. And so
Yeah.
I just don't know the answer, and I was hoping
Yeah,
somebody
well,
might know the
but I guess
answer.
I don't know how you would transfer the tax credit to your investors in a C corporation because it's not a pass-through entity. Again, I'm not a tax partner at my firm. One of my tax partners could answer the question more intelligently, but I've never heard of being able to transfer an R&D tax credit in a C corporation to the stockholders.
Yeah,
Yeah, so
it's kind of like a dividend.
I understand the intent. What I think both Ahmed and I are saying, we've not heard of it being done or even possible.
Okay, fair
Okay.
enough. Okay,
Yeah.
thank you.
The other thing that you mentioned is that if you I understand you're trying to give something back to the investors, and it sounds like it might be a good deal if it was structurally possible. But you did say one thing is that you would convert the investors to common, and in many cases, investors will not want to convert to common because they lose huge preferred equity rights. Okay.
Ah, okay. So we'd have to just give it to him as a dividend. or an equivalent to it, because we're allowed to, according to what I've read, we're allowed to give them the investors this credit. And
Yeah, well, I think frankly this is sort of outside the scope of this
okay,
discussion, but
okay,
happy to introduce you to my tax partners if you want to chat with them
okay.
about them.
Thank
Yeah.
you. Okay,
Yeah. Okay.
thank you.
hmm So let me see. We are over, Amit. Amit, if you can you stay for a couple more questions?
Oh, sure.
Okay. Let's see. I'm trying to figure out. There's a lot of questions trying to see. Um, Yen asks, will safe preferred stock be classified as a derivative embedded equity?
I don't it wouldn't I don't think it would be a derivative. It'd be treated the same as preferred stock. So it wouldn't really be a derivative. It's a convertible instrument, but I mean, I guess it theoretically is a derivative of common stock, but you wouldn't typically classify it as a derivative.
Okay. There are a lot of questions where, honestly, um, the question in the chat lacks context. There's partial information suggesting that, describing a certain situation, but to offer any type of opinion, it's helpful to have more facts, knowledge of facts and circumstances. Okay. Um, Burton
I've got to
has.
jump at 11:10.
Okay. Why don't we do one more question? I'm trying to find a general, broadly applicable question. Please clarify safe like economics. Okay.
Oh, sure. So whether it's a safe or series safe preferred stock, if you invest $1 million at a $10 million post with a on a $10 million post money valuation, whether it's through series safe preferred stock or a Y Combinator safe, before you convert to the next round, before new money comes in the next round, you represent 10% of the cap table generally. And then when the next round occurs, let's say another $10 million is raised uh, at a $10 million post money value, a pre-money valuation. So 20 million afterwards, then you would go down from 10% effectively to 5%. There's a bit of nuance there, the way it's based on what the option pool is increased and all that, but that's a basic idea.
Mhm. Okay. Got it. Maybe one other question that hopefully is a little bit shorter. If you sign a Series Safe preferred investment agreement, what happens if there's no price round, no big price round after that?
If there's no price round after that, you're still a stockholder. You still share in dividends the way you would if you were a stockholder. It's all based on the post-money valuation cap, but you have those voting protections necessary. You've got fiduciary duties owed to you. So you are a stockholder even though no price round occurs versus a
Mhm.
safe, you may never be a stockholder.
Okay.
And so
And w when there is a voting situation, if you hold one share of preferred stock, how does your vote count?
yeah, your vote is all everything is based on the investment amount and
Okay.
the post-money valuation cap. Uh, and so it's you take out the unissued option pool, the unissued options, but basically you use the same calculations you use for converting in a liquidity event as you would for voting and for dividends.
Okay, got it. And I just noticed another question that I thought might be helpful. There's a question about valuation caps on safes, and is that potentially viewed as a negative? And one thing to provide context, if you look at the Carta data, the vast majority of safes that are signed, about 90% of them, are valuation cap. Okay. And in fact, excuse me, not Carta, Y Combinator removed the discount plus val cap version of the safe, I believe. So even though you may feel like a valuation cap is not something that you want, it's something that an investor wants usually, and it's typically what is done. Amit, any other thoughts and comments on val
Yeah,
caps or
well,
safes?
some people worry if I put a valuation cap, then I'm setting a valuation,
Hmm
and and then so that's going to hurt me in negotiating the next round. If you did the next round the next day, that's true. But I think the assumption is you're going to use, and you should be thinking about this, you're going to use that money to get to some valuation milestone, and then you're going to raise additional capital. So you have to be able to argue that something different happened, and hopefully something different did happen. If you just went sideways, you're going to be in a bad position regardless, and nobody may put any money in. So you have to assume and be hoping for, with founder optimism, that you're going to do something between the raise of the safe or Series safe preferred and the next round that's priced.
Very good. Awesome. We are over, and I want to respect your time, Amit. Thank you very much. Sorry we couldn't address all the questions. If you do have other basic questions about safes, we do have the event next week, which I had highlighted earlier. We would love to be able to have you join that event, and hopefully we can get some of those questions answered then. Thanks
And I'll
again,
put
Amit.
my email in the chat if anybody has any follow-up questions. But thank you, Sam, for setting this up. And I appreciate all the information you have on your site. I think people should take a look at it. But thank you very much for including me. It was a pleasure.
Yeah, thank you very much.
Cheers,
Okay,
everybody.
bye.
If this was helpful, please like this video and subscribe to our channel. You can also check out our other videos for more startup content.